technology. Apologies. Yeah.
I know. That's the thing, you go there and as soon as you walk in the door, somebody starts. One of these.
Graham, we seem to be live now, so if we're okay to start, I'm sure I can start recording if needed.
Right, could you do that for us, because I don't know what's happening at this end of my...
Yeah, that's fine.
Right, I'll leave.
Right, okay. Can I just ask everybody that's in the call, those that are actively participating should have their video on, and then anyone that's just here observing, if you could turn your video off.
Callum, can I just say I'm getting quite a bit of feedback when you speak.
That might be coming through my laptop, I think. Once I mute, it might go back to normal.
Okay.
If you're happy to get started, I can start recording now.
Okay. I think we'll give it a go. Okay, well, good morning, everyone. Can you all hear me? Yes, that's good. Well, good morning and welcome to this virtual pre-inquiry meeting. The purpose of today's meeting is to discuss the procedural arrangements for a public inquiry into objections to the A9 and A86 trunk roads, Crubenmore to Kincraig, compulsory purchase order, trunking order, side roads order, and extinguishment of public rights of way order, all required for the dualling as proposed of the A9 between Crubenmore and Kincraig. These orders are proposed to be made by Transport Scotland, acting on behalf of the Scottish ministers. There are objections to the orders that have not been withdrawn. My name is Andrew Sykes, and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, generally known as the DPEA. And I've been appointed by the Scottish ministers to consider the orders and the objections made to them, to hold a public inquiry, and to rewrite a report for them. I will be making findings of fact and recommending whether or not the orders should be made. Before I go any further, there are a few things I'd like to say about today's meeting, some of which you've already heard. Firstly, the meeting is being broadcast live to the DPEA website, and that a video record of the meeting will be retained on the website until the ministers have taken a decision on this matter. In addition, by taking part in this virtual meeting, you are consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to them for webcasting and training purposes, and for the purposes of keeping historical records and making those records available to the public. Secondly, while we're all becoming increasingly familiar with virtual meetings and proceedings, could I nonetheless ask you to keep your videos turned on throughout the meeting and to mute the sound unless you wish to speak, of course. You might also find it useful to have your screens on gallery view, which I think is the case with most of you. If you need to attract my attention, please raise your hand or wave and I'll see that you wish to speak. Thirdly, and importantly, if you're part of a team participating in this meeting and there is more than one of you in a room, could you please ensure that you observe safe physical distancing from your colleagues at all times? If it becomes apparent that parties are failing to maintain safe distances, I will unfortunately suspend the meeting. As mentioned in the meeting invitation, it is possible for parties represented by more than one person to join the meeting on a separate line. Now, I don't envisage the need for a break during this meeting, but just ask if anyone feels the need for a short break at a convenient point. Are there any questions from anyone before I go any further?
No, thank you.
Okay, thank you. Now, could I please ask parties taking part in today's meeting to introduce themselves? I'll start with Transport Scotland and then the RSPB. I will then ask the Royal Zoological Society to clarify its position in light of an email that I received this morning, informing it that it had unconditionally withdrawn all its objections to the proposed scheme. So, Mr. Milne.
Thank you, sir. Good morning.
Good morning.
My name is Douglas Milne. I am a partner with Morton Fraser LLP, and I'm instructed by Transport Scotland. I am joined today virtually by officers from Transport Scotland, Ms. Moksha Beam Singh and Mr. Andy Anderson. We're also joined virtually by two members of the joint venture who are advising Transport Scotland in connection with this scheme, Mr. Andy Torbert and Ms. Gwen Greenwood. Lastly, I am joined by my colleague, Ms. Vary Foy.
Okay, thank you very much. Mr. Campbell.
So good morning. I'm John Campbell. I'm a Queen's Counsel at the Scottish Bar. And in this case, I'm instructed by the Royal Society for the Protection of Birds, who are represented by Turkin Connell, who are not present today, and Miss Rosie Sutherland, who is the resident solicitor at the RSPB. She is on this call, along with her planning colleague, Miss Esme Cleland, and our land agent, Mr. Peter Series of Savills.
Thank you. Mr. Ferguson.
You're muted, Peter.
Good morning, sir. My
Good
name
morning.
is Peter Ferguson. I'm a partner at Harper MacLeod and I represent the Royal Zoological Society of Scotland. I don't believe that my clients have joined the meeting, but apologies to them if they have.
Okay. And would this be an appropriate point of which for you to clarify the email that you sent to my office yesterday?
Yes, sir. Discussions have been ongoing between Transport Scotland and my clients for some considerable time. And late yesterday evening, we managed to finalise those arrangements. And in consequence of that, my clients have now unconditionally withdrawn their objections to the scheme.
Okay. Okay, thank you for that clarification. Do you intend to remain in the meeting, or are you wishing to make your leave?
I will remain for 15 minutes or so, more out of interest, but I will now mute myself and I don't anticipate to speak again.
Okay, well, thank you for that very much. Thank you. Is there anybody else involved in this meeting today that's not been mentioned by Mr. Milne or Mr. Campbell? Okay.
As far as I can see from the list of participants.
No.
Wasn't anticipating anyone else.
No, thank you very much. Okay. The second item on the agenda is just to clarify the purpose of today's meeting. The purpose of the meeting is solely to discuss the administrative arrangements for the inquiry and the prior disclosure of cases that parties intend to lead. There will be no discussion concerning the merits or otherwise of the orders or of parties' cases. And for the avoidance of any doubt, I should also make clear that compensation issues are beyond the remit of the inquiry. You should all have received a copy of today's agenda, which was sent out by my office on the 2nd of October. I thought it would be helpful to attach to the agenda a series of notes on the points that we need to discuss today, including a schedule of objectors and the status of their objections, and a possible format for the inquiry, which we'll discuss shortly. I hope that this will have given parties time to consider these matters and make for a more effective meeting. It was, however, written before the recent additional measures to address the ongoing coronavirus pandemic before they were introduced. And on that note, given that the Scottish Government's response to the pandemic is under constant review and further guidance is expected to be announced later today, I do not rule out the need for possibly a second pre-inquiry meeting to review any of the arrangements that we might agree to during this meeting. The third item is the legislative context in which the inquiry will be taking place. Now, the orders are proposed to be made under the Roads Scotland Act 1984, and so far as relating to the compulsory purchase of land, the Acquisition of Land Authorisation Procedure Scotland Act 1947. The relevant ministers are the Scottish ministers, as these functions have been devolved under the Scotland Act. The compulsory purchase by public authorities inquiry procedure Scotland Rules 1998 apply to compulsory purchase by Scottish local authorities. There are no specific rules in place for inquiries into compulsory purchase of land by the Scottish ministers. However, the normal practice is to apply the same principles as set out in the 1998 rules to govern the procedures of such inquiries. Are there any comments on the legislative context?
No, sir.
Thank you.
Not for me, sir. Thank you very much.
Thank you. There's also an associated circular explaining in plain English how the rules work. That is Circular 17 of 1998. If those unfamiliar with the rules intend to take part in the inquiry, I recommend that you take time to read the rules and the circular, and I will provide links to these documents in my note of today's meeting. Now, turning to item 4, participation and structure for the hearing of evidence. My understanding is that it's only the RSPB that has indicated that it wishes to give evidence at the inquiry, and as required has submitted an outline statement of case. By the deadline of the 10th of July, the Royal Zoological Society aside, no other statutory or non-statutory objector had been in touch with my office to say that they wished to appear at the inquiry. Is that also your understanding, Mr. Milne?
That's correct. There are no other parties who have indicated directly to Transport Scotland or to my firm that they were wishing to participate.
Okay. Thank you.
I wonder if I could intervene.
Yes, please do. Yeah.
Try and be helpful. The presentation of this agenda is extremely helpful, and thank you for doing it. It's enabled my clients to organize their thinking in a constructive way. They have been working with both Mr. Milne's team and Mr. Talbot's team at the joint venture with a view to reconciling those objections which are highlighted in the outline statement of case. The objective of these discussions has been to try to assemble a form of undertaking or undertakings which will meet the objections and provide the necessary preventive or administrative measures which will allow the project to proceed whilst safeguarding the interests which the RSPB espouses and considers important and significant in relation to the reserve. Inevitably, because there are a number of topic headings, such a document is bound to be lengthy and detailed. The intervention of the coronavirus pandemic and also holidays has meant that this process has become rather more protracted than one would have wished, but it is complex. And I wanted to assure you this morning that people are continuing to work on it. Now, the objective, of course, is to reconcile all of the issues. So far, that hasn't happened, but I can say to you that a number of the issues, a good number of the issues, have been reconciled, both administrative and practical on the ground, and that I see the potential for further progress in the coming days and weeks. So whilst I know you have an agenda for this meeting today, on the basis that there will be a full-blown examination of some sort. I just wanted to assure you that that work is going on, and I wouldn't say it's likely to, I won't stick my neck out and say it's likely to yield fruit, but I'm hopeful, of course, that it will.
Okay, well, thank you for that. That's very helpful. I wonder if this is a good opportunity, Mr. Milne, for you to be able to update the status of the objections. Your statement of case very helpfully at Appendix C set out the number of objectors and their current status. Since then, of course, there's been a number which have been withdrawn, and I think I would appreciate perhaps an update on where you are with those objections.
Yes, sir. So taking note 4 of your agenda, now I appreciate your office has been updated, but I agree it'd be helpful to go through this list quickly for others who may listen to this meeting as well, so as that they are aware of the most up-to-date position. So highlighting the changes from note 4, objector number 3, the Highland Council, withdrew their objection on the 27th of October. Yeah. Simply a note for your information, objector number 5, Ruthen Farm, Thomas Hone. Mr. Hone has apparently sold the property, and Transport Scotland and the joint venture are in touch with representatives of Mr. Hone to find out whether that objection is maintained.
Thank
you. I would just note in respect of objector number 7 RSPB that Mr. Campbell is of course correct. Discussions are ongoing between the parties with a view, if not to resolve the objection in all respects, to narrow down those issues insofar as possible. And the procedure which I will propose, subject to your consideration, very much is with a view to actually assisting parties in terms of narrowing down those issues. Objector number 8, the Church of Scotland. Your office has received an email which referred to a conditional withdrawal of that objection. I am in contact with Bolt's Chartered Surveyors on behalf of the General Trustees of the Church, seeking clarification as to their position, and hope to be able to confirm to your office very soon that objection has been withdrawn unconditionally. And that, of course, is subject to the discussion that I have with Bolts. Number 10, Ballaville Estate. Your office has received an email from Brodie's on behalf of the estate referring to discussions which are ongoing between the parties. That objection is maintained for the time being, but we're hopeful that will be capable of a resolution by the grant of an undertaking, but we can come on to discuss procedure in respect of that objection should it not be possible to resolve it.
Okay.
Objection number 11, Royal Zoological Society of Scotland. I'm grateful to Mr. Ferguson for confirming that objection was withdrawn yesterday evening, and I'm grateful to him and his clients for the work that they put into helping to resolve that matter. Otherwise, I have no further update in relation to the objectors listed up to 18, or in relation to the non-statutory objectors highlighted as being supporters of the RSPB's position in relation to the Inch Marshes. There's also no update in relation to Mr. Veen, who appears at the very end as a statutory objector at number 60.
Okay, thank you for that.
So I wonder if I could ask Mr. Milne through you if he could repeat what he said about objector number 10. I didn't pick it up properly.
Indeed, Mr. Milne, if you could, please.
Yes, no problem. Ballaville Estate, represented by Brodie's, there is an ongoing discussion with Brodie's with a view to trying to resolve that objection by the grant of an undertaking. However, as at today's date, the objection is maintained, and Karen Hamilton was in touch with the DPA yesterday, asking if a date could, or if the estate could be allowed to lodge a written submission as at the date of lodging of documents, if required.
Thank you very much.
Scotland will seek an opportunity to respond to that. So that's the position in relation to Ballaville.
Thank you, Douglas. That's very kind.
No problem.
Okay. I would like to now discuss how evidence might be heard. Before we do, of course, the impacts of the pandemic will have a bearing on how the inquiry is progressed. As you may have read, in the most recent DPA coronavirus guidance, our default position is that inquiries and hearings will be undertaken virtually, and only when the overall position improves will consideration be given to in-person inquiries and hearings. Furthermore, this will only be where the inquiry is considered to be essential, where local restrictions allow, and at venues where appropriate physical distancing, hygiene, and tracing safeguards can be guaranteed. So in this context, I'd ask the parties and their representatives to consider progressing their cases, or as much of their cases as possible, by a written representation procedure, and that's the message I'm hearing from what has been said thus far. That said, with regard to the structure of the inquiry, in its outline statement of case, Transport Scotland has helpfully suggested a structure around which evidence might be heard. Clearly, we've had a withdrawal since that statement was prepared from Network Rail and the Royal Zoological Society. And it was based around sessions that considered the design development of the proposed scheme, individual and site-specific objections, and of course impacts on the Inch marshes. And Transport Scotland has added that where objections are not supported by an expert witness, it would be content for matters to be dealt with by way of written submissions. It will be essential, however, to have at least one inquiry session to enable any applications for the award of expenses to be made if parties are intending to do so. And those arrangements are set out in Circular 6 of 1990. So before I ask for comments on the suggested structure, I wonder, Mr. Milne, if you could, is there anything you'd like to add to that structure that you set out in the outline statement of case, given the time that's passed since you prepared it and the subsequent discussions that you've been having? So I'd be grateful if you could update us. Thank you.
Yes, thank you, sir. Yes, you're quite right. Inevitably, the procedure is such that the outline statement of case was prepared some number of months ago, and also was prepared, had to be prepared on the assumption that many of the objectors would wish to participate. But we're in the position of the only other participant being the RSPB. So on that basis, I don't see the need for any number of separate sessions. The RSPB's interests could most efficiently be dealt with in one session, which focuses on the Inch marshes. And we would understand that the RSPB would be the only participant there because none of their supporters have suggested that they wish to come along. I have discussed matters to some extent with Mr. Campbell, for which I'm grateful. And what I was going to propose, obviously, we've managed to get to the position of not having any other objectors who wish to participate. So those objectors who are maintaining their objections will be dealt with in writing. So I think a significant amount of the inquiry can be dealt with in that way. But the RSPB objection does raise, as Mr. Campbell has already referred to, a number of complex matters. And there will be a number of expert witnesses who will be required to come along and give evidence. So my proposal today is that the RSPB objection is dealt with in one inquiry session. All issues to be considered at that session, other than the legal points which have been raised by Mr. Campbell in his outline statement. For example, his reference to a submission on the entire legal conservation framework and also on land right issues, insofar as they relate to matters of law. Appreciate inevitably you have a bit of an overlap into some factual points, but I'm sure Mr. Campbell and I can work together to agree on what most appropriately can be dealt with by way of a legal submission to be lodged in advance of the inquiry. As regards the RSPB supporters, I note, sir, you have made a reference in the notes to the agenda that they could be perhaps dealt with by way of a separate written submission. Given that there is inevitably some overlap between what the supporters have said and the RSPB's position, albeit there is some divergence because the supporters are insisting upon a number of points which the RSPB has confirmed it is withdrawing. My view is that overall the most, well, the easiest way of proceeding would be for the entire Inchmarsh's case to be set out in the inquiry statement of Transport Scotland and in our witnesses' precognitions. We will prepare those documents very clearly to explain where the point is being dealt with by a supporter which is not being relied upon also by the RSPB, in order to avoid the confusion which I'm trying to avoid by suggesting this process. This is the way that, and Mr. Campbell's familiar with this as well, this is the way that we dealt with the inquiry at the beginning of the year for the duelling of the A9, which related to in part the Killiecrankie battlefield, where there were a number of objectors who appeared at inquiry, but also a significant number of written objections made in relation to that issue. And again, we covered all of those written objections in inquiry statement and precognitions in order to avoid parties and the reporter from having to look in several places for the evidence. I was also going to suggest the order in which we could proceed by way of lodging inquiry statements and propose some dates. And I'm not sure if it would be helpful for me to do that now, or sir, if you've got any questions or wish to invite Mr. Campbell to comment on what I've said so far.
Okay. I think I'd like to hear from Mr. Campbell first, but certainly we'll come back to that point in a moment. So Mr. Campbell, your thoughts on what Mr. Milne has just had to say.
Thank you very much. I think three things come out of this. The first is possibility of an inquiry session on expenses. It's self-evident that that session could actually be in writing. We have no present intention in that regard, but I can't speak for other objectors. So that may be something that you can provide for, but ultimately won't need. We are content that supporters can be dealt with separately, but I think Mr. Milne and I should liaise as to who we're talking about so that we can then talk to them and see if they are genuinely divergent from the RSPB or whether it's simply nuanced and the case can be brought together. I suspect it's the latter, but I don't know that yet. The principal proposition from Mr. Milne's submission is that we deal with the RSPB case as a whole in one inquiry session. We think that there is merit in that. We're concerned that an inquiry session may be more protracted than is necessary, and that you might feel that because you're the reporter and can dictate the issues that you want to be instructed about, you might feel that a hearing session would be just as valuable. But I absolutely see the merit in what my learned friend Mr. Milne is saying, and would prefer I think, to leave it to you as to whether these matters merit an inquiry. On the one hand, where you have competing experts, experience suggests that an inquiry session is more useful than a hearing because it enables parties to put their cases more resolutely and, I hope, more succinctly, although that isn't always said about lawyers. On the other hand, if the reporter knows what he wants, which of course all reporters always do, then the reporter can direct the questioning to those experts, perhaps having them sit together in an inquiry so that they can define or refine the matters where they're not in agreement. The objective, of course, is not to sacrifice everything on the altar of time, but simply to make the best use of that time. It's often said that saving an inquiry time is a virtue of its own. Well, it can be, but things can get left out. I'm anticipating that our discussions will continue to be fruitful and that we may be able to bring the experts together. So I'm sorry, that's a slightly long-winded answer, but I think really nearly on all fours with Mr. Milne on all of the things that he said.
Sorry if I may.
Yes, certainly. I was going to invite you to speak.
Comment briefly on that. I agree with everything that Mr. Campbell has said there, and I think it's fair to say I would be speaking on behalf of both of the parties by saying that in terms of these discussions as they are ongoing, they are with a view to resolving matters or narrowing issues. And we will be focusing not just on the draft of any agreement, but on the content of, in the first instance, an inquiry statement. So as I sort of move on to talking about timing, if parties are lodging very full inquiry statements, but not for, say, 6 weeks, that allows another chunk of time where parties can have this discussion about what can be agreed, but can also discuss what needs to go into their respective inquiry statements. So we immediately have a narrowing of the issues phase. I know, sir, that it can often be the case that inquiry statements are required X number of weeks before the commencement of inquiry, but I think here requiring the inquiry statements within 6 weeks of today's date would be, it's a helpful focusing of the minds, but again, parties being as detailed as they can, because that may assist with what comes next in terms of the lodging of reports. If I may go on and say that
yes, please.
I've largely discussed with Mr. Campbell, but there's another point I was going to suggest. If we can start with the actual inquiry, which, in light of what I've just said, may be narrowed in scope, or it may be that Mr. Campbell and I can discuss coming to you at some point in the future and say, actually, we've identified an issue which could be described as a discrete issue, could be dealt with in writing, whatever, then that's an option which I'd suggest remains open. Yes. Now, I would suggest, given the potentially technical nature of the evidence, that having lodged recognitions 4 weeks before the inquiry session, parties consider whether rebuttals would be helpful and lodge those 2 weeks before the inquiry session. Now, I'd not want to encourage extra work simply for the case of it, but it is again with a view to the complex nature of this evidence potentially, and also the fact that this is going to be a virtual inquiry. So it is a case of fixing an inquiry, but the more that can be committed to writing, the better. So that's my thinking. Now, I gratefully receive others' thoughts on that. Documents, including reports, 6 weeks before the inquiry, together with the written submissions, which I've referred to in respect of those objectors who are not participating, and legal submissions. Statement of agreed matters 8 weeks before the inquiry. I've mentioned inquiry statement 6 weeks from today. And then the last thing in my note is to go back to the Ballaville estate. Transport Scotland, of course, is hopeful that will be resolved, but if it's not, noting that Ms Hamilton of Brodie's would like to reserve the right to lodge a written submission. Transport Scotland has prepared the draft of a fairly detailed report, given the nature of the Ballaville estate, which we think would be very helpful to you in terms of understanding the background to the scheme as it impacts on the estate. And we would like to lodge that before Brodie's lodge their submission. So I would suggest that with documents and written submissions, including Brodie's submission being lodged 6 weeks before the inquiry, we perhaps lodge that Ballaville report, the objective report, 8 weeks before the inquiry, which may immediately be making you think this inquiry is now unlikely to be taking place at the beginning of January. All of these deadlines, which I think are helpful, and the parties working together should achieve the aim of narrowing issues and getting as much on paper as possible, would lead to an inquiry taking place at the earliest in March, which I understand would be acceptable to the RSPB. But of course, we've not discussed that with you.
Well, you're right. That was my thought, that a January start was like disappearing over the hills, you know. But Mr. Campbell, any comments what Mr. Milne has to say about how a timetable might unfold towards an inquiry?
No, I'm very happy with the idea of 6 weeks for a statement of case. I'm very happy with the, I think you said 8 weeks for statement of agreed matters. That's 8 weeks before.
Mm-hmm. Yes.
I wasn't clear whether you're talking about 8 weeks from today or 8 weeks from the backwards from the inquiry date.
Before the inquiry.
Before the inquiry. So can we just begin again? You're talking about, we haven't fixed an inquiry date yet, but in every case you're talking about dates prior to the inquiry date, not from today forward.
Correct. So working back from the inquiry, 2 weeks before the inquiry rebuttals.
Yes.
4 weeks before the inquiry recognitions. 6 weeks before the inquiry documents including reports. Also 6 weeks before the inquiry written submissions, which I appreciate you may not be involved in, and legal submissions, which you would be involved in.
Yes.
8 weeks before the inquiry, statement of agreed matters and the Ballaville Transport Scotland report. And then the only deadline calculated from today's date, 6 weeks from today, being the inquiry statement.
Yeah. Well, if you ask me for comment, I'm very happy with those dates. My clients and I have checked in January, and we have real difficulty with at least 2 weeks in the middle of January. So I have cases in other courts which will last in each case a week. And so that, and we have all the post-New Year inertia, which is familiar to everybody, plus the difficulties of COVID. So I don't know how you're placed for March, or whether you have a view about that, but it seems to us that that's a pretty realistic
right.
Date.
I mean, I'd like to give every opportunity for matters to be resolved, and I hear what Mr. Milne says about ongoing discussions. So, you know, I don't want to frustrate those discussions by imposing an unnecessarily early inquiry start. So I'm quite happy to let those discussions take place, and to better able to define, you know, what the inquiry will have to consider. So I think that's a very good suggestion. So in terms of my availability, I don't foresee any difficulties in being available for March, to be honest with you. So others might have other work might be coming my way, but if I know that there's a likelihood of an inquiry in March, that's fine. I can make myself available for that. And the sooner I know that, the better. So that's very good.
Yes,
Well,
I can say that at present, as matters presently stand, I don't have any professional commitments in March.
Okay.
But diaries fill up in an extraordinary way, and something may come along. But at the moment, I'm free.
And Transport Scotland and our witnesses are free throughout March as well, and would be keen to fix those dates today, if possible, in order that we know that there isn't a risk of losing those dates.
Sure. Well, would it be useful perhaps to discuss how long parties might require to present evidence, and then we can see which dates might be suitable in March? So I don't know if you...
Yes, Mr. Campbell and I again had a very helpful conversation about that, and I understand that RSPB could have 4 witnesses. Transport Scotland, now of course it does depend again on what's agreed, could have between 8 to 10 witnesses. Inevitably there are a good number of disciplines which need to be gone through, just not just the environmental and ecological ones, in order to fully explain the promoter's position. If Mr. Campbell doesn't mind me explaining, I understand you anticipate that your evidence could take, say, 2 days. Now, having reflected on my conversation with Mr. Campbell earlier in the week, I know we're both keen to wrap this all up within a week or 5 days. I'm a bit concerned about whether progress through a virtual inquiry may be slower. And also getting through 8 to 10 witnesses in 3 days may be a tall order if Mr. Campbell has got lots of questions. So I wonder if we could always aim high and try and get the inquiry completed within 5 days of evidence, but keep a number of days in reserve if that's not too inconvenient for people the following week.
Okay.
I have an open channel to my clients, and the week beginning the 23rd of March is not suitable for them. But that apart, March does seem to be suitable. Because we're in the middle of resolving issues, I can't be precise about the number of witnesses, but I did discuss 4 with Mr. Milne, and for the moment I'd like to stick to that.
Okay.
And I think we should, if I may say so, reserve 5 days, because it's much easier to row back from that than it is to augment it. I think 2 weeks would. I think 2 weeks would be extravagant in this case, and we don't need it.
Okay. So, is there a preference, Mr. Milne, for which, I mean, if we, the first Monday or first week in March is the 1st of March, would that be a good one to aim for?
Yes.
Okay.
So I'm not sure if you would be content to sit on the Monday as well and have the full 5 days, which again, I hear what Mr. Campbell says about 2 weeks being excessive. I absolutely agree that 10 days, 8 days is excessive. I just would hate to run out of time and not be able to find new dates to complete the evidence for a number of months, given the imperative on the part of Transport Scotland and ministers to be progressing this matter. So if it is possible to keep a number of days in reserve during the week of the 8th as well, that would be my strong preference. But a start date on the 1st or the 2nd, if that's your preference, sir, of March is absolutely fine.
Okay. Okay, I think we'll work on that basis then. I know the practice is not generally to sit on a Monday, but I'm happy to do so if that would help. But I think we'll probably work on the basis of starting on the 2nd, and we can review presumably the start date depending on how discussions go over the next couple of weeks or 6 to 8 weeks, and see. Okay, well, thank you.
Mondays used to be reserved for travelling to the venue, but of course.
Yes.
It said that gentlemen don't travel on a Sunday. However, we're all in our own living rooms now, so
Indeed. Indeed.
that's a refinement that we don't need.
Okay, I hear that.
It's up to you entirely, of course.
Yeah. Okay. We've got through that rather more quickly than I was anticipating. But Mr. Milne, in your outline statement, you did say that you would perhaps use this meeting to seek some assistance on alternative sites. I don't know whether the discussions that you've been having with various parties has narrowed down what you're hoping to clarify in that regard, but I did note that in terms of alternative sites, there was a suggestion, well, I think there was a note that you had made that the RSPB had, you were keen to establish whether they would insist upon additional land being sought to deliver kind of offsetting measures. And I don't know whether that has been discussed in the discussion you've been having so far, or whether it's still a live issue for you.
I think it would be, without going into the detail of the discussions, I think that the adequacy of the mitigation which is being provided as part of the scheme is very much a live issue, currently destined for inquiry, but it is in certain respects being discussed between the parties. But I think in light of what Mr. Campbell has said in his outline statement, subject of course to anything else he has today, I don't actually think we are in the territory of an alternative as is being discussed by the rules, because the RSPB is not proposing an alternative for the scheme. It's more criticising the adequacy of the mitigation and is suggesting that could be addressed by certain offsetting measures. But I don't think we'd be in the position of identifying additional land and calling the owners of those land to the inquiry to express a view about their land being acquired through further orders. I don't think we're in that territory, and I don't think that would assist. I think we're better continue with the discussion about adequacy and debating before you whether the mitigation is in fact adequate, if that's a point insisted upon by these objectors.
Okay.
I agree with that analysis.
Super.
I completely agree with that analysis. It's about sufficiency, not about an alternative venue at present.
That's good. Okay. We've had that. Okay. I think you've helpfully addressed most of the matters that I had in mind, Mr. Milne. So unless there's anything else to say on dates and the timings of submission of documents, etc., before the inquiry, I'm quite happy to move on to talk about the publication of documents, if that's okay.
Yeah.
Yes.
Yes, okay. The Coronavirus Scotland Act 2020 lifts any statutory requirements to make documents physically available for public inspection if it might give rise to significant risk of transmission of the virus, or is likely to be ineffective or inappropriate due to the action being taken to control the incidence or transmission of the virus. Nonetheless, it remains necessary to publish documents online and give electronic notice of the decision to do so. The view of the DPEA is that it should be sufficient to email objectors about where they can find the documents relating to the case. And I'd just be interested to hear from you what your thoughts are on that matter and how exactly the documents might be published.
Thank you, sir. In at least one other A9 inquiry, the decision was taken simply to advise members of the public that documents would be available on the DPA website. And what Transport Scotland also did on its own website, the section dealing with the A9 dualling programme was put up notice that in any interested parties, if they were looking for the inquiry documents, should follow the link to the DPA website. And I would suggest that that's a sensible approach to take here again. Before the pandemic, other than in that instance to which I'd referred, Transport Scotland had developed the practice of providing a local library with a laptop with the documents on it. I'm not sure if it was ever used, but that was the way of making the documents available. That library is the library which Transport Scotland has suggested, but I would suggest that you dispense with that requirement, and Transport Scotland can put a notice on its website directing parties to your office's website.
And in the case, the section of the A9 that you refer to, there was no difficulty. People didn't say that I couldn't find the information or anything like that. So
no, and of course, if any interested party was encountering any difficulties, if they let my office or Transport Scotland know, we would provide them with those documents by way of a USB stick. Would I suspect be the most helpful way for anybody, or email if they were only looking for a number of documents.
Okay.
So experience suggests that works well. Might ask my learned friend also if he or his clients would post a notice in the local post office, for example, or a local library, just so that people have a physical notice that they can refer to. Difficulties have arisen in parts of Scotland where internet connection is poor. And I think in particular of wind farm inquiries, of which I've done a few, in remote places, particularly to the north and west. These are difficulties which are quite hard to overcome unless you have the sort of compliance from the promoter, which Mr. Milne has indicated his clients are willing to provide. So I don't know what the internet reception around King UC and Newtonmore is, but I can't imagine that it's that bad, because it certainly works up and down the A9 perfectly well.
I don't see any difficulty with asking Badenoch Library to put a notice on its notice board, which we can prepare for them regarding this public inquiry and how to access the documents.
Thank you.
Thank you, that's helpful.
And the documents are already helpfully set out on the Transport Scotland website, and that's actually a better point of reference than I'm going to say in the DPAs, but just to be in any way rude. It is a bit, a DPA website is sometimes tricky to manage, let's put it that way.
Okay.
But we one way or another, we have access to everything we need.
Right, okay. That's super, thank you very much. The next item on the agenda was site inspections, or is, I should say. I mean, owing to the travel restrictions in the early part of the pandemic, I haven't made any detailed site inspections that are referred to, of sites referred to in the objections, and neither have I arranged to visit any sites before an inquiry. And I just wonder, before any arrangements are made, it would be able to hear from you whether or not site visits are considered essential, and if so, whether there's an alternative way for me to to see the sites, whether that's through the use of photographs or videos. And of course, if you are to rely on photographs and videos, they would need to be made available prior to the inquiry. So be good to hear from you on that point. And of course, if any site visits were to take place in person, they would have to take place after the inquiry, and would most likely take place on an unaccompanied basis. So, so I'd be interested to hear your thoughts on if it is possible to convey everything that needs to be conveyed through the use of photographs and a video rather than actually an in-person site visit.
Thank you, sir. Yes, I mean, I could never say that a site visit was anything other than essential in terms of fully understanding the arguments being made, not just in relation to the RSPB, but in relation to those parties who have made objections and are resting on their written submissions. So what Transport Scotland would propose to do is to provide you, sir, if this is acceptable, with a proposed itinerary for your own site visit in due course, but to give that to you before the inquiry over the course of the following weeks. But that itinerary wouldn't simply be instructions as to directions you were to take, but Transport Scotland will embed in that photographs, including aerial photographs, and we'll also be able to provide you with some drone footage of certain parts of the land here. There are, significant constraints in terms of the drone footage which was able to be taken because of limits on proximity to the Highland mainline railway, and also in terms of the A9. So the drone footage is quite limited, but we still think that will be helpful for you to see. So in summary, we can provide you with quite a lot of photographs supplemented by drone footage. We'll identify for you from where those photographs have been taken and the direction in which they have been taken. And we will aim to get that to you in the following weeks. It may take some time to collate it all, but we do think that would be helpful in advance of the inquiry. Of course, I've no difficulty at all. Of course, we wouldn't with letting Mr. Campbell see that material insofar as it relates to his client's interests before it's provided to you, in order that he can be content with what we've produced.
Mr. Campbell.
Thank you very much. We regard it as essential that you carry out site inspections. Whether those are accompanied or unaccompanied ultimately is a matter for you, but we don't really see why there should be any difficulty with an accompanied site inspection, provided social distancing is observed. Now, we have resident managers on the reserve who are, of course, well aware of the rules, and it doesn't seem to be beyond the wit of man to travel in separate cars to the various locations. Now, this is a matter we can come to agree the fine print on later on, but Mr. Milne and I are quite able to cooperate on preparing an itinerary for you, whether that be accompanied or unaccompanied in the end of the day, I think is a matter for you. We're, of course, quite happy to rely on you to go to the places you say you'll go to and draw, but experience suggests that an accompanied inspection ultimately is more valuable. So I would ask you to think again about that and not work from a default position of an unaccompanied inspection. So far as graphic material is concerned, as you'd expect, the Royal Society for the Protection of Birds has a great deal of photographic material, and so far as it relates to this case, we will try and collate a modest amount of it so that you're not overwhelmed with paper or graphic material for your screen. Whether that includes drone footage or aerial photography, I don't know at the moment. I imagine there might be some, but we're focusing on the area for the A9 dueling, not on the wider interests of the RSPB in preserving the waders population. So interesting though that is not the question for this part of the inquiry. It's to help inform your decision-making about the extent of the works and the accommodation works and so forth. So I would join with Mr. Milne in agreeing that some graphic material should be made available. I can see that would be helpful to you, but I would sort of underline the importance, if you like, underline the importance of having a proper inspection of the site, whether before, during, or after the inquiry itself. Okay. If we're in March, we're in the springtime, but the Kincraig weather is notoriously unreliable, and and there may be difficulties, maybe genuine difficulties in making the inspections particularly to high ground if that's necessary at that time of year. Just have to play it by ear.
Okay, thank you very much.
So I look forward to hearing from Mr. Milne in due course, or his team, with a draft itinerary, if I may.
Yeah, thank you.
That's grand, thank you. Right. I was just going to say a few words for the benefit for those that are watching the webcast. If people are unfamiliar with the details of the orders, all the relevant documents can be viewed on the DPEA website by entering the case reference CPO-270-8 into the search facility, and you should be able to access most of the documents, if not all of the documents on that site. All contact with the DPA should be through the case officer. That's a lady by the name of Smira Akbar. And Smira's contact details are noted at the end of the agenda, and I'll include them again in my notes of the meeting, which I hope to circulate sometime next week. But other than that, unless there's any other business that Mr. Milne or Mr. Campbell wish to raise, I've nothing further to ask. So, Mr. Milne?
No, thank you, sir. I've nothing else to add other than to thank you for this morning's meeting, and look forward to progressing matters over the course of the next couple of months.
Okay, well, thank you very much for your help. And Mr. Campbell, anything?
Can I join Mr. Milne in thanking you for the meeting, and
yeah,
we will do what we can to achieve reconciliation.
Okay.
And I don't say do without an inquiry, but narrow its scope as far as possible. You never know, Mr. Milne, you could smile. But
okay.
Okay.
Right. Well, just say apologies for the little technical hiccup at the beginning, but I think it's probably worked reasonably well. I think it's not been too bad, and bodes well for a virtual inquiry should we find ourselves in that situation. So, well, thank you very much.
Thanks, sir.
And I'll formally close the meeting now. Thank you.
Thank you.